and welcome to another episode of Simplifying the Law. If you are new or if you are joining us for another episode, this is an initiative by the government of Guyana through the chambers of the Attorney General and Ministry of Legal Affairs to, as the name would suggest, simplify or break down the laws of Guyana. As you, the viewers, may know, the government has a very robust legislative agenda. This year in 2023 up to August, 19 pieces of legislation were passed in the National Assembly, and these are modern, complex pieces of laws which require some level of technical expertise to break down and get into. And that is what we hope to achieve through this initiative and through this program. So here we bring to you the experts who are able to break down the provisions of the laws and identify the sections which may be relevant to you and which may not be relevant to you, or identify penalties within the legislation, and just educate and inform you of general provisions of the laws of Guyana. Now, this is a program for you, the citizenry, the viewers, for your benefit. It was, and that was the idea in mind when the initiative was crafted. The reasoning being is that we have so many laws, and like I said, so many more are being enacted on a yearly basis, and therefore it is imperative that we have some sort of discourse about what these laws are, and the government thought it fit and necessary to bring to you this program. So today with me I have two young ladies from the chambers of the Attorney General who will help me to go through the Adoption of Children Amendment Act 2021. So again, this is a fairly new piece of legislation, and it introduces some new concept into the Principal Act. So, but before we get into it, I would just ask them to introduce themselves to me, starting with Miss Oslisa.
Thank you, Richard. My name is Oslisa Marks. I'm State Counsel within the Ministry of Legal Affairs within the Litigation Department.
Thank you. And Miss Haynes.
Good morning, everyone. I am Ms. Haynes. I am Parliamentary Counsel within the Office of the Chief Parliamentary Counsel at the Attorney General's Chambers and Ministry of Legal Affairs.
Thank you. So, the Adoption of Children Act, or more so this specific amendment that we're going to dive into today. If you could start us off by telling us what is this amendment, but briefly touching on the principal legislation as well, what it entails.
Okay, thank you, Richard. Thank you for this opportunity. I believe that the affairs of children in general should be given the utmost importance. The Adoption of Children Amendment Act, number 8 of 2021, implemented into our legislation, the legislation of Guyana, the Hague Convention on Protection of Children and Cooperation in respect of inter-country adoption. This piece of legislation, this amendment, brought our law into conformity with the international best practices and standards on specifically in relation to inter-country adoption.
Okay, and the amendment, the 2021 amendment, does this. It introduces something specific into our legislation. What is that?
It introduces the inter-country adoption. Inter-country adoption is where a child resident in one country, habitually resident in one country, is placed in the permanent care of a person habitually resident in another country in accordance with the Hague Convention. So it allows, in our case, it allows for a Guyanese child who is in need of adoption to be adopted by a person from another country, a country being a convention country, allowing that person to adopt a Guyanese child who is in need of adoption. A convention country is a country who also would have signed on to the Hague Convention.
Okay, thank you. So the Hague Convention, you've mentioned the Hague Convention, and what are the objectives of the convention? And are they provided for by the legislation?
Great question. Well, as you know, there is a big issue of abduction around the world, and this is common knowledge. So the Hague Convention seeks to create a system of cooperation amongst convention states to safeguard the children and their family against abuses and risk of illegal, irregular, or ill-prepared adoptions abroad. It's also allows inter-country adoption. It operates in a system whereby it recognizes and reinforces the United Nations Convention on the Rights of the Child, specifically with regard to specifically recognizing the principle of the welfare of the child and the best interest of the child being paramount, and having regard also to the fundamental rights of the child. The convention as well is a system whereby it secures the recognition of adoption, so that when an adoption certificate is presented to any country, a convention country, that adoption certificate is recognized in that country. So essentially, this convention and our amendment, the Adoption of Children Amendment, the main objective and purpose is to create a safe and secure environment for inter-country adoption to guard against abuses, abduction, and sale and trafficking in children.
Right, and throughout you've been mentioning inter-country, and this is specifically what the Act provides for. So what are some of those the convention countries which the Act recognizes?
Some convention countries are Australia, Belize, we have Botswana, we have Canada, Ghana, the United Kingdom, the United States, and of course Guyana. The full list of countries is available on the website of Hague Conference on Private International Law.
Okay. When did Guyana sign on to this convention?
Guyana acceded to the convention on the 5th of February 2019. However, the convention did not become applicable to our law until the amendment, the Adoption of Children Amendment Act of 2021. So, though we signed on to the convention in 2019, it was still necessary for our parliament to then go and implement this amendment to our Adoption Act to bring the convention into force and effect into our local and domestic law. This is given that Guyana has a dualist system.
Right, and we need to ratify.
Ratify, correct.
So, if we could just take it back a bit to touch on what the law was prior to the enactment of this Amendment Act.
Yes, so that is a great question. And prior to the amendment, local and international adoptions were and currently are governed by the Adoption of Children Act, Chapter 4604, and the Child Care and Protection Agency Act, Chapter 4607. So generally, the function of the Child Care and Protection Agency is to assess applications for foster care, guardianship, and adoptions, and they also have the responsibility of assisting the court in any investigations as it relates to these guardianship, adoption, and so on. The Adoption of Children Act provides for persons who wish to adopt a child to make an application to the Child Care and Protection Agency in the manner provided by regulations. So the regulations would set out the process. Under this Adoption of Children Act, the board has the duty to receive applications and to also make investigations. They may also apply to be a guardian ad litem for the child who is the subject of the adoption. And what a guardian ad litem is a person appointed by the court to look after and protect the interests of someone else who is unable to do so. The board is also empowered to make recommendations to the Child Care and Protection Agency, who makes the necessary arrangements for the adoption of the child. The agency and the board work together at all points to ensure that the adoption goes through as smoothly as possible and the child is protected. And as it relates to international adoptions, we would have also made provision for this before the amendment. However, this process was not as seamless as it should have been, and that is why the amendment is important. So prior to the amendment, the Adoption of Children Act made provision for a non-Guyanese who is a person, a non-Guyanese or resident living permanently outside of Guyana for the court to make an adoption order for them. Also, a person who is not domiciled or resident in Guyana could also be a part of the adoption. However, a report would have to be given from the agency in that country where the person is living. So as I was stating earlier, the difference is prior to the amendment, this system was a bit decentralized and a bit more complicated. So what the amendment did is for persons who were part of convention countries, as Osalisa would have mentioned, the process is now simpler with the introduction of central authorities within both countries, where the child is and where the adoptive parents are. So that is what the amendment did.
Okay, thank you for that elaborate explanation. And if you could take us into the safeguards of the amendment.
Yes, so the safeguards of the amendment, as with every piece of legislation and these sensitive adoptions, we have to ensure that the child, the parents, and the adoptive parents are protected. So we have 3 safeguards. The first is cooperation between countries. So the amendment ensures that the central authority cooperates and collaborates with the central authorities in the other countries, as well as the agencies that are involved, and that would be the different adoption agencies. Under Article 7 of the Convention, the central authorities must promote cooperation among each other, and they must achieve the other objects of the Convention. They must also provide information as to the laws of their state, as well as statistics and standard forms. For example, regulations that we have in the draft stage, we have consent forms that will be used within the process. The central authorities also have the responsibility to keep each other informed about the operation of the convention and to eliminate any obstacles to its application. For example, if while the process is going on, the central authority would notice that we have a situation here that is making it a bit difficult, they may come back to the Ministry of Human Services and Social Security and say, we notice that there's an issue and it may be remedied by another amendment to the Act. So this is also part of the central authority's responsibility. Another safeguard would be protection of the process. So the process under the Convention encourages and calls for confidentiality and for safety of the information shared between the countries. So information about the child's biological parents, and the adoptive parents is secured. The amendment seeks to ensure the protection of everyone involved in the process. And this would include thorough investigations, home studies, and criminal background checks to ensure that the person who is adopting the child is suitable to do so and that the child will be protected when they're in the care of this person. Provision is also made for a general penalty, as Richard would have mentioned earlier, in case of breach of the provisions. And where someone is liable on summary conviction, there is a fine of $500,000 and imprisonment for 6 months. Additionally, any agency operating under the convention is required to be accredited before they can do anything on behalf of the child or the adoptive parents. This also ensures that everything checks out for any agency that is operating under the convention. As I stated before, we have also made provision for consent, and so the relevant consent need to be had by the parents, the biological parents of the child, and the biological parents and the child. They're also informed about the process and the effects of their decision, because this is a very important decision that will be made, and so they need to be fully informed of what exactly they are doing. And these consent will have to be made in writing. The third safeguard relates to no improper financial gain, and under Article 32 of the Convention, it makes provision and provides that no person is to derive improper financial gain or any other gain from any activity related to such adoptions, and only reasonable cost must be paid or charged. Additionally, any director, administrator, or employee of any agency involved should not receive remuneration or money which is outside of their ambit. It should not be unreasonably high, because you do not want anyone to feel like they have an unfair advantage in the process. Everything should be above board so that the process moves on smoothly. So those are the three safeguards: cooperation, no financial gain, and protection via the process.
Okay, thank you. And throughout you've been mentioning the central authority. If you could get into what is the central authority?
So the amendment makes provision for the Minister of Human Services and Social Security, the Honorable Dr. Vinya Prasad, to establish a central authority to discharge these functions under the convention. So this central authority will be the Guyana Central Authority for Hague Matters, and they will be responsible for carrying out these functions. However, you might be wondering, where is this authority? I've never seen it anywhere, I've never heard of it, and that is because the government is currently in the process of setting up the authority. So once the order is passed establishing the authority, we will also have regulations which will be passed, which will govern the operation of the authority as well as the inter-country adoption process.
Okay, and does the legislation provide for the composition of the authority? Who makes up the central authority?
Yes, the legislation does provide for their composition, and as I stated before, the minister who has oversight will be the chairperson, and the minister will also appoint 5 other members to the authority. The first person would be an attorney at law of not less than 5 years standing. Then we will have 2 persons appointed from the Child Care and Protection Agency or another similar organization. We will have 1 public officer from the Ministry of Home Affairs. So this person would be designated by the Minister of Home Affairs, and the final person would be a public officer from the Ministry of Foreign Affairs. And the last 2 ministries are very important because Home Affairs deals with immigration as well, and Foreign Affairs, we're dealing with different countries. So those are the important persons.
Right. I know just now in your discussion, you touched briefly on the work of the central authority, but if you could go deeper into what the functions of the central authority are for us.
Well, I'll let my colleague, Ms. Marks, go into that.
Yes, the function of the central authority include cooperating with the central authority in the other convention state on matters relating to the implementation and administration of the provisions of the convention. They must also ensure that appropriate measures are taken to fulfill and carry out the provisions of the convention, as my colleague mentioned. They are also to provide the relevant information to the other central authorities in the other states, in the other convention states, on matters regarding the accreditation bodies, for example, and whether such whether such bodies would have their accreditations have been revoked or suspended. The central authority is also responsible for advising the other central authorities on our legislation, particularly in relation to the convention. And they must also provide all other relevant information that will carry out and implement the convention. In general, the central authority must ensure that they keep in constant communication with the other central authority and contracting states to ensure that the other central authorities are informed of the process and informed of all the steps that are taken to bring the process to completion. So, for example, if a child needs to be placed in the temporary care of a prospective adoptive parent, then the central authority is responsible for monitoring that process and for ensuring that the other central authority or contracting state in the process is informed and they are to ensure that that process comes to completion. My colleague also mentioned that if there appears to be an issue or the system is so rigid or there's some complication, it is incumbent upon the central authority to address any issue and make the process simplified so that the process could go through smoothly for both the child and the adoptive parents and all the parties involved.
Okay, thank you. Earlier you mentioned an adoption certificate, which is a requirement in the process. So if you could touch on what is this adoption certificate and its effect for us to explain that.
Sure. The adoption certificate in itself is conclusive evidence that an adoption took place in accordance with the convention. So once that convention is presented here in Guyana or any other convention state, it is evidence and it will be recognized and give effect to as a legally binding document.
And can the recognition of an adoption be refused?
Yes, of course. It may be an adoption certificate may be refused in a contracting state only if it is found to be manifestly contrary to public policy, having regard to the best interest of the child.
Okay. And I'm sure the right circumstances must exist before you can adopt a child. So if I may ask the question, under what circumstances is a child adoptable?
Yes, thank you. So a child is adoptable or considered eligible to be adopted where they are under 18, has never been married, and where they're habitually resident in Guyana, meaning that their permanent residence is here. However, even though a child may be adoptable, the central authority may only approve the adoption where the central authority or the Child Care and Protection Agency has considered all of the circumstances in relation to the child, and they have determined that the child is eligible. There is no other suitable placement in Guyana, for example, with another relative or a legal guardian, and that the adoption is in the best interest of the child. Additionally, as we would have mentioned before, consent is very important, and so this must be done in writing before any other step could be taken.
Okay. So we've had quite an extensive discussion on the procedure on how to go about doing the inter-country adoption. So if you could set it by way of an example, set it out first by way of an example, the procedural requirements for fulfilling an inter-country adoption.
Yes, thank you, because I'm sure persons may be wondering that as well.
Yes.
So the example I will use will consist of where two two persons or a person is in Guyana, so they will be the adoptive parent, and they're looking to adopt a child in Canada. So first of all, Canada, as was mentioned by my colleague, it is a convention country, and so they will also have a central authority. So the first step, the parents in Guyana will have to apply to our central authority here. And the central authority will then, who already has an accredited body, this will be the Child Care and Protection Agency, they will carry out the necessary investigations. And once that is done, the results of the investigation will be forwarded to the central authority. So then the central authority will prepare a report on the suitability of the adoptive parents to adopt. And of course, this will include thorough background checks, criminal background checks, home studies, and so on to ensure that the environment is right for the child. And once that is done, a report will be sent to the central authority in Canada where the child is. And the central authority in Canada, they will then use their accredited body, whichever adoption agency that is, to determine if the child is adoptable. And once this investigation is done by the central authority and the accredited body in Canada, the body will then send the results of the investigation back to the central authority. Once this is done, the central authority will prepare another report on the child, and this will also include the necessary consents that I would have mentioned before by their legal guardian or their biological parent. Once this is done, they will send all of that information to the central authority in Guyana. However, before anything can go on, there must be a written agreement between the two central authorities, ensuring and agreeing that the parents are eligible and that the child is adoptable. Nothing can go forward unless this is done. So once there is that written agreement, an adoption order is applied for by the court in Canada, and this is done by their adoption agency. And once that order is complete and received, the central authority in Canada will then prepare the adoption certificate as mentioned by my colleague. And once this adoption certificate is prepared, it will be sent to the central authority in Guyana. And as my colleague was stating earlier, this adoption certificate says that the adoption is recognized and it will be effective in whichever convention country. However, the final step, as stipulated by Article 18 of the Convention, refers to the central authorities of both states taking all necessary steps to ensure that immigration is right in Canada as well as in Guyana, to ensure that the child can leave Canada safely and quickly and without any problems and enter into Guyana to meet with their loving family, their adoptive parents, without any issues. So that would be the final step in the adoption process.
And does the legislation speaks to an adoption order rather than the certificate?
Yes, it does. And my colleague will look at the effect of the adoption order.
Yes, so under Article 26 of the Convention, that spells out what are the effects of an adoption order. There are three legal effects, being that it establishes the parent-child relationship between the child and the adoptive parents, and it transfers legal responsibility for the child to the adoptive parents. It also terminates the parent-child relationship between the child and their biological parents if it has this effect in the country where the order was made. Those are the legal effects of the adoption order.
Thank you. I know this is a relatively short piece of legislation, and therefore there isn't much to expand on, but thank you both for going through the act so thoroughly. Before we wrap up, I would just give you the opportunity to share anything I might have missed, or your general remarks on the legislation.
Yes, thank you, Richard. As with everything, we do need to sum up. And I would just like to reiterate certain things for the citizens of Guyana or anyone who is listening. Just be reminded that the amendment brings our laws into conformity with international best practices, and this is important to safeguard the interest of our children. The amendment ensures cooperation between the countries. It protects the process and the information that is shared, as well as prohibiting persons from receiving improper financial gain through the process. In case of queries, you may contact the Ministry of Human Services and Social Security, as they have oversight, or the Child Care and Protection Agency, as they play a very important role in this process as well. As it relates to the authority, we would have mentioned prior that it has not been set up as yet. However, when it is, you will be informed of that. And as this authority is very important in this process as well. We will also be publishing regulations which will govern the process and the operation of the authority. Please also remember that the amendment only applies to a child who is eligible to be adopted and who needs to be adopted. And there are many steps within the amendment that will secure the process. Thank you.
I don't know if you have anything to say or add, Miss Marks.
Not really, but I just want to add to my colleague that it's only a child who's in need of adoption that would be adopted by someone, a foreigner. So there are certain steps that needs to be followed before we come to this stage. The central authority must exhaust all avenues to have the child adopted in Guyana, either by a relative or a Guyanese citizen. And this is like the final opportunity for the child to be adopted.
Okay. This is quite a comprehensive piece of legislation. It deals with a sensitive issue, and it provides the relevant and necessary safeguards to protect against any misuse, I would say, of the intention of the legislation. So I guess that has brought us to the end of today's episode. Like I said, this is a very small piece of legislation, and therefore it's not that large and to go through. So, as I would have mentioned at the beginning of the program, this is an initiative by the Government of Guyana through the chambers of the Attorney General and Ministry of Legal Affairs to educate and enlighten the citizenry on the laws of Guyana, new laws that are being passed, and even laws that are already in existence. Some persons might not know of them, but as our Honorable Attorney General says, ignorance of the law is no excuse, and therefore it was thought necessary that we do initiatives like this, such as this program, to educate the populace on what the laws are, and not only penalties or punitive measures within legislation, but also things which might be for their benefit. So for example, the Adoption of Children Amendment Act 2021, as we've discussed today, persons are much more educated in relation to an inter-country adoption now. So that is the intention and objective of this program, and I hope we have been fulfilling that mandate thus far. Well, that is it for today. Until next time, I am your host, Richard Bainey. With me today, I had Miss Osalisa Marks and Miss Ariel Haynes. Thank you both for joining me today and going through this legislation.
And thank you for having us as well.
Yes, thank you.
The government of Guyana is taking all steps to ensure that our roadways